Hey everyone, and welcome to today's video. In this episode, we're continuing the story of a pro se defendant who was caught trying to steal from his store and has chosen to represent himself against the so-called fake lawyers prosecuting him. Today's proceedings appear to be a probable cause hearing, which will determine whether there's enough evidence to suggest that a crime was committed and that the defendant is likely the one responsible. We have quite a bit of testimony and video surveillance to review, so let's get started.
This is going to be case number 25S00791FY, People of the State of Michigan versus Timothy Dansby. Sir, what's your name? All right, Mr. Dansby, good afternoon. Mr. Shockley, place your appearance on.
On behalf of the people.
All right, today is the date scheduled for a preliminary examination. This is on one count of retail fraud, first degree. People prepared to proceed.
Yes, Alex.
All right, any preliminary matters?
Did you, pursuant to the court rule, confirm that the defendant still wishes to represent himself as this is a critical proceeding?
No, but do you still wish to assume he did?
Yeah, it just has.
He's been-
voluntary.
He's just been asking all this time. Would you still want to represent yourself? You've been telling us all this time. Do you want to represent yourself?
I've been wanting to represent myself.
Okay, so you want to proceed today by yourself without a lawyer, right?
Not before I let it be known that I still never received my full discovery.
Well, what haven't you received, sir?
I haven't had a chance to go over the videotape because one of the witnesses in the videotape that I know that when I was speaking to him and was saying, letting him know that, look, man, put this stuff back on here because I'm choosing not to buy it here and I'm going someplace else. So it wasn't like I was trying to steal nothing when I told the guy this particular, I wanted to make sure that he's being available to be questioned.
I don't know who he's going to call. See, this isn't a trial. So this is just your probable cause hearing. So the prosecutor has a very low threshold burden of proof. He doesn't have to put on every witness, he said. He doesn't necessarily have to use the video. He might. And if you say the video means something else, that creates a question of fact that would go to trial for the trier fact to resolve. And of course, you get an opportunity to question about the video in depth at trial.
Also, I'd like to mention the fact that, you know what I'm saying, that it's been a delay because I don't know who these people been coming up here. I've been telling the court that I've been wanting to represent myself.
Well, you've been representing yourself since the last time.
Well, I've done with them at the county jail. They said without the court allowing them to know that I was representing myself, there was certain information I couldn't get. They would not give me. Like the Michigan court rules of evidence. You know what I'm saying?
I've never heard of the court having to tell the jail you're representing yourself. I've never heard of that.
The new technology, they used to have a law library you could go. But now you do everything over the computer.
Okay.
You got to leave a request. In order for them to fulfill your request, they have certain criteria that you got to show ahead of time.
Well, sir, I don't know anything about what the jail's criteria is.
And also, I'd ask, for a standby lawyer.
But they don't do that.
But from my understanding from previous experience,
I love your enthusiasm, but I don't think that previous court appearances count as experience when it comes to defending someone against criminal charges, including defending yourself. As far as standby counsel goes, that's a privilege, not a right. So if you need standby counsel, then you probably need to just let a lawyer represent you fully to begin with.
What year was that?
Federal circuit court and from other court.
Federal Circuit Court.
No, I know it has to be a circuit court. They have done.
This is the state system.
There has been opportunity to have standby lawyer for instances where they could confer certain information that the prosecutor might not want to give to me because he might feel he's better than me or something. Because he feels that my counsel doesn't like.
Listen, Mr. Dansby. We can't keep.
He might allow me to receive.
No, of course you got. That's not true. You have a right to represent yourself and you do have a right to get discovery. But what you can't do is come in here on the day of the hearing claiming that, oh, now you want to stand by counsel. Okay, but I'm telling you.
I'm just saying, well, from my experience, it's always been standby counsel's been set.
I don't know what your experience is. I just know what Michigan and I don't know when you got.
Well, of information.
Okay, sir.
And
The Michigan Indigent Defense Rules, they have a whole new program that's been started a few years ago. So we used to do standby counsel and anything like that. We used to do that all the time when the court was appointing. Now they have a whole system. They don't pay for that. They say if the defendant wants a lawyer, fine, but there's no quote standby lawyer in their view, so they don't pay for that. I didn't make that rule. I
couldn't verify it if I wanted to without
the person that
without the people in the jail who's running the law library information able to send me the information that I need, because without them having and for their quote,
okay, what information
their quote unquote,
sir, what information do you think you need just for a preliminary exam?
Your Honor,
No, I said for Michigan Indigent Defense appointment.
So then you said it used to get standby counsel.
I said we did before that system was created.
Well, I want all the chance to update on the system, y'all.
Okay, but that has nothing to do with this.
Court rules of evidence.
Your Honor, I'm gonna, just so I can expedite this, and to satisfy the defendant, at the circuit court level, the circuit court has the budget and the ability and the staff to appoint a standby counsel once he gets up there. And once we finish this hearing, he may be up there and he can make that request then, and I'm sure the circuit court will have no problem immediately assigning him an attorney to advise him as he represents himself. As far as the people are concerned, the court rules been complied with. He's freely and voluntarily relinquished his right to an attorney. May I call my first
So
witness?
the court, I like to also state that I still haven't received my discovery, and my date was postponed because of some guy who said he was my attorney. I did the extra 30 days.
Well, if you keep this up,
That's my attorney.
you're
You're
gonna be here another 30 days. Do you want me to adjourn this case again?
No, I don't want to talk. I'm really actually having dismissed.
No,
For the simple fact that
we're not doing that.
or ask for a personal bond, because I've been had my cases adjourned on other people's.
Sir, you the one that asked for new lawyers or no lawyer.
Ask for any new lawyer because I never accepted the first. I have never signed for an appointment of an attorney from the very beginning, even at
Okay, sir. Well, we're gonna proceed with your preliminary examination without a lawyer. So you should be happy today that you don't have one. And then when you get to the circuit court, ask them to give you a lawyer. He just said they have a budget for that.
ask them to give me my discovery.
What discovery don't you have? What tape?
Your Honor, I'm gonna play the tape for him, today anyways. There's no right to it. There's not even a right to discovery before a preliminary exam, technically underneath.
I appreciate your enthusiasm, but previous court appearances don't really count as experience when it comes to defending someone against criminal charges, including representing yourself. As for standby counsel, that's a privilege, not a right. So if you find yourself needing standby counsel, it's probably a sign that you should let a
This is
qualified.
just an intermediate proceeding. It's not gonna affect anything. As you know, attorneys don't even ask questions a lot of the times during preliminary exams because it creates a question effect.
But they certainly don't call. They might ask questions, but they don't call witnesses.
Not in all situations. With all the preliminary exams, but there's.
Okay. Have a seat, sir, unless you want to stand up for the whole hearing. Okay, Mr. Shockley, are you ready?
I am ready.
Okay. Raise your right hand. Do solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth.
Yes, sir.
All right, thank you. Have a seat. And Mr. Shockley, whenever you're ready.
Yeah. Sir, when you are ready, will you please state and spell your name for the record?
Yes, it's Robert Sammons. R would be ERT. Last is SAMMONS.
Who is your employer?
Meyer,
What is your job title with Meyer?
Asset Protection Team Lead.
Asset Protection Team Lead?
Yes, sir.
And how long have you been employed in that capacity by Meyer?
Since January of 2025.
Did you receive any specialized training to have that title or that role?
Yes.
And what do you do? What kind of training?
So it's a multitude. So over years, Wicklander certified, and then different courses in asset protection and policy related, that kind of stuff.
Are those courses designed to help you detect retail frauds or patterns of retail frauds?
Yes.
Yeah, next question. Were you employed in that capacity on July 26, 2025, around five 5:30 p.m.?
Yes, sir. Okay.
And so, do you work at a specific Meijer store or multiple stores?
I'm assigned to the one in Southwood.
Is that located at 28800 Telegraph Road,
Yes,
City of Southfield,
yes,
County of Oakland?
yes.
On that date, around that time, did you identify a retail theft in progress?
Yes.
And how did you identify that?
In this particular case, it was just rapid selections of similar merchandise.
What do you mean rapid selections?
So one of the indicators of theft is grabbing merchandise without looking at price or without appearing to look at price, size, that kind of thing.
And how did you see this occurring?
On the floor.
Were you physically on the floor or were you watching cameras?
Sorry, I was physically on the floor.
Did you follow this individual
I did.
as he was selecting items?
Correct.
Do you see that individual you're following presently in the courtroom?
I do.
Will you please point and identify an article of clothing he is wearing?
It's the over to my left, and he's wearing like a blue shirt with a white t-shirt.
Your Honor, may the record reflect the proper identification of the defendant?
Yes, so ordered.
Upon following this individual, did at one point he come to the point of sale?
He did.
Was that before, at any point did he try to walk out before coming to those points of sale?
No.
Did he have a cart or was he concealing these items on his person?
It was a carton.
Was that cart full?
Yes.
Upon him going to the point of sale, what did you, just so we put, you were at the point of sale when he got there.
I was, yes.
And what did you see him do at that point?
He went up to a cashier and myself and asked where the bathroom was.
Was that before or after the cash register?
That was, it's kind of at the same time. It's like at a, it's like a giant area where there's like self-checkouts.
Are these self-checkouts?
Yes.
Is there a long looping line to the self-checkout?
Correct.
Okay. Did he still have the cart with him?
He did. So he left the cart, actually by me, and then he went to the restroom.
And what did he do? Did he come out of the restroom?
He did.
And what did he do upon coming out of the restroom?
He grabbed a cart and proceeded towards the opposite side of the store, which would be the grocery side.
And what did he do upon getting to the grocery side?
He pushed the cart out, exiting the store without offering payment.
When you say he pushed the cart out, is there a double door vestibule to Meyer?
Yes.
Did he enter
what?
a double door vestibule?
Vegetable.
Vegetable.
Oh,
Not
vestibule.
vegetable. Yeah.
Okay, got it. Okay, go ahead.
Yes. So it's basically what it is. It's an opening with EAS towers, and then he pushed past those EAS towers.
What is the EAS tower?
Electronic article surveillance that detects the tags, that the merchandise protection tags on merchandise, the thing that beeps when you pass it.
Did they beep?
None of these had tags, so no.
Okay. Did you stop him at that point?
Yeah.
Did he say anything to you upon stopping him?
He said, I can't recall exactly what he said.
But he did say something?
He did.
Okay. And what did he do upon you confronting him?
He walked past me and then went out the doors going to on the grocery side into the parking lot.
Did he abandon his car or did he try to take his car with him?
He abandoned it.
Did you retrieve this cart?
I did.
Were you able to scan the items that were contained within the cart?
Yes.
Upon scanning these items, was a receipt produced?
It was.
Yeah, may I approach the witness?
Yes.
People pose exhibit 1. So I take a second look at what I just handed you. What is that?
It's a receipt from Meyer.
And does it fairly accurately pick the items you scanned from the cart?
Yes.
Has that receipt been edited in any way to your knowledge?
No.
People will go to that People's Exhibit 1.
Show it to the, him. Okay, sir, that is People's Proposed Exhibit 1. Hello? Well, he's offering it. Is there an objection? Okay, no objection heard, admitted.
Commissioner, approach and publish.
Yes.
Thank you. Sir, does, monitor camera,
We do.
and were those cameras working operational on that day?
They were.
And did, upon him leaving the store, did you contact law enforcement? Did law enforcement come to your location?
They called him, like in the, they went towards 12 Mile, made a right. I'm sorry, I don't know if it's east or west, but made a right. And then they caught it right there. And then they came.
Okay, so to answer my question, law enforcement did come to your location?
Yes.
Upon them coming to your location, did you show them video for the incident?
Yes.
Previously to you taking the stand, did I show you what's on the splash drive?
Yes.
Is what's on the splash drive, the videos from my road that day?
Yes.
People were moved to next people's proposed exhibit 2.
Sir, any objection?
People's proposed exhibit 2 is the camera footage from mine, correct?
Yes.
And that's the same footage we turned over to the police? Yes. People were moved to next people.
I object to the fact, John, that I haven't had a chance to go over, take previous to the examination. You know what I'm saying? I'd like to state for the record that being able to go over there would be part of my discovery. And since the prosecutor said, I guess upon his word, I guess he's making precedence with that. You don't have to give.
But why don't we do this, sir? Let's play the video without admitting it so you can watch it. Then if you have an objection, you can.
Now, this is where I have to push back a bit. According to MCR 6.201(a)(6), the defendant is entitled to any and all evidence that will be used against him, including video evidence. Under this court rule, he has the right to a description of and an opportunity to inspect any evidence that may be introduced at trial. The prosecution's argument, however, is that the defendant did not properly request discovery on his own, so they aren't required to produce it until he does. But just moments ago, the defendant made a verbal request to the judge for discovery. In my opinion, this is where the hearing should have paused, allowing the defendant time to review the video evidence, and then reconvened once he had the opportunity to do so.
Why should he step out? He's already seen it.
But he ain't seen it when I'm looking at it. He might be making them different.
No, we're not. He doesn't have to step out. We're going to show you the video. Go ahead, sir. There's your video.
I'm straight.
You said you haven't.
Video. I was there.
Well, you said you wanted to see the video.
I was present, John, when.
Sir, either one way or the other. Are you objecting to the video? Yes or no?
I don't know if it's the whole video or not.
Okay. So
Run the video.
go ahead, play it.
Sir, if you would turn around and look at the screen, is this, one of the videos you provided to?
And I just, I'm
You can stand.
happy, sorry. It's just.
So you showing the video for him or for me?
We're showing it to you, but he's gonna.
You tell him to turn around.
Well, he's gonna identify what it is.
I mean,
Then
if it's my time for me to watch the video, then I watch the video. When it's his time to ask him a question, then he can watch the video.
let's have him identify what it is he's showing. Let's at least do that. Okay, let's do that. Go ahead, Ms. Shapley.
Sir, is this a video you turned over to Southfield Police?
Yes.
Is that actually you in the video?
Yeah, that's, being go on right now.
Okay.
All right, no more questions. Just let him watch it.
Wait, this is at the, this is gross exit view. This is at the 17-hour, 53-minute mark. So was that you walking out with the,
No questions. Just let him watch it first.
well, that's under that one. That's him leaving the store. He left the store.
I can see what it is. Just let him watch it. Then we'll come back and you can ask questions once he objects or I admit it or whatever, because I'm not admitting it yet.
This video is later labeled GM SCO overview.
Okay.
To the 17-hour, 47-minute mark.
I can't see.
Okay, well, why don't you walk up there closer?
I'm stopping the video at 17 hour, 49 minute, 12 seconds.
Okay, is that it?
Yes.
All right, sir. Head back to your seat. So that's the video that he seeks to admit. Do you have an objection?
Yeah.
What is that?
Complete video of the incident that happened. Because at this junction right there, I was going.
In my opinion, this is where the hearing should have paused, allowing the defendant time to review the video evidence, and then reconvened once he had the opportunity to do so.
You can make an argument later. The question is this the video that purportedly was taken by Meyer cameras and turned in by this witness to the prosecutor's office? He said that's what it is. Now, you can question the validity of it, the length of it, how long it was, but doesn't affect the admissibility of it. So, okay, so it's submitted. So you want to ask him some questions now, Mr. Shacklin?
Yes, Donna.
Go ahead.
This is of two, just for the record. Sir,
So you want to stand up and look again?
Oh, no.
He's gonna take you,
Oh, you want me to go?
I'm gonna go back.
he's gonna go back to that first video.
Yeah. You go.
I got look. I'm gonna ask him to play that back.
So is that you confronting the defendant?
Yes, sir.
When he was walking onto the exit, is that after he abandoned his cart?
Like this part right here, you're talking?
Yeah.
Where's the cart
Do you see the lady?
with the pink hat?
No, ma'am, the, one with like the dark pants and the black shirt right
The
there?
Meyer outfit?
Yes, ma'am. The cart is right there just in front of her.
I'll run it back.
That's the part I'm trying to see. You don't mind.
Yeah, go ahead. Mr. Shy. Oh,
At that point, is when he walked up with the cart, right?
Yes.
And one of your associates takes it away from him?
Correct.
Okay, and then you confront him.
Oh, wait a minute. Oh, you said somebody took the cart away from, where is that at? You should have shown me that. You think,
okay.
ask the question, I'm asking you to show me.
Sir,
Yeah.
no, you don't ask the prosecutor questions. You have to ask the witness questions.
Well, I don't have access to go to the reground and take myself, yeah, because I haven't been allowed my copy of the tape or the electronic.
Well, it's not your time to ask the questions yet. You get a chance to.
I don't have a copy of the tape to go.
Sir, you don't need it. You watched it.
Well, I'm watching it, I'm trying to verify what's going on.
Okay, but you're not doing it right. You have to wait till he asks the witness questions,
Okay.
and then you'll get a chance to ask the witness questions too.
Sir,
I'm on it.
you see the person in the middle of that video that looks like he's got a white stripe at the bottom of his leg?
Yes, sir.
Okay, is that the person you identified as the defendant?
Yes, sir.
Okay, that card he appears to be holding it in his hand. Is that the card you took the items out and then scanned to create that receipt, which was People's Exhibit 1?
Yes, sir.
Okay, people are good fun.
Where's the copy?
It's right there at the entrance by that lady in the blue shirt and pants. She's holding it.
How did we get them?
You were,
I take it.
sir, if you watch the video, it shows you He identified you pushing the cart, and when he got to that part, they stopped you
Okay.
and took the cart.
Now they took the car, but there was an individual, it was a young black male.
Yes, sir.
It was, hold on, y'all.
But just, you're not testifying.
It was a young, I'm not testifying.
Yes, you are. You're trying to tell us your story, and this is